Okay, so what I'm talking about today is looking specifically at one use of technology and whether that indicates diverging standards between the EU and the UK in the field of law enforcement. And the area I chose to focus on is live facial recognition technology. And I chose to do so because it's going through quite a lot of legal developments at the moment, and because there's an interesting corollary going on within the EU with the EU AI Act. So that's sort of the reason I chose to focus on this area. When I'm talking about this, I am specifically looking at the use in publicly accessible spaces for the purposes of identifying an individual, because there are different categories in which this can be used, but the framework will differ depending on the purpose. I think it's also important to note here, in the context of the UK, this is largely something for England and Wales, because policing is a devolved matter within the UK. Scotland has a moratorium on the use of live facial recognition technology at the moment, and Northern Ireland, as far as I'm aware, as I've been able to find, has yet to adopt live facial recognition technology, although there is support for doing so. So a lot of the provisions I'll talk about are specific to England and Wales. Okay. So in the context of adequacy and thinking about how this might impact on adequacy, I look specifically at the law enforcement directive because that facilitates the information sharing procedures between the EU and the UK after Brexit. Similar to the GDPR, it's subject to an adequacy decision. And the adequacy decision was adopted as part of the wider practice in June of 2021. Similar to the adequacy decision on the GDPR, there's an emphasis on the adherence to the fundamental rights instruments and the ECHR in particular, and the jurisdiction of the ECHR. Similarly as well, under the provisions of the adequacy agreement, one of the provisions is that the member states and the Commission shall inform each other of any indications that interferences by the United Kingdom public authorities are going beyond or interfering with the rights of individuals and going beyond what's strictly necessary. And strict necessity is an important criteria, particularly when talking about biometrics data, which is the type of data which is engaged with live facial recognition technology. And the adequacy decision emphasizes that there need to be effective legal protections against such interferences. And this is important because where these don't exist, where the interferences are going beyond what's strictly necessary or where there's not effective legal protection, then the adequacy decision might be amended, it might be repealed or withdrawn or suspended. And in assessing whether adequacy applies, the test is not one of like for like provisions. So following the case of Schrems, the test is one of essential equivalence. So whether through the substance of the rights and their effective implementation, supervision, and enforcement, the system as a whole delivers the required level of protection. And so to that end, I aim to look at whether the use of live facial recognition technology is guaranteeing that effective level of protection as required. And in this, there are a lot of areas that are, of course, contentious with the use of facial recognition technologies. I focused on a few of them because there are just too many to cover in one paper, but I look specifically at the legal framework governing the use of the technology, the use of watch lists and how that may or may not comply with the requirements of strict necessity, the oversight mechanisms, and then the potential for private-public collaborations in the use and deployment of the technology. So to give you an overview of the legal framework and the situation we're at in the UK at the moment, of course, any interference with fundamental rights must be in accordance with law. So it's necessary to have a legal framework which governs the use of the technology. With the use of facial recognition, though, it's quite piecemeal, and we find provisions in a range of different areas, although there's a lack of specificity and a lack of clear link to the technology. So within policing more generally, we have common law powers, which say that the police may do what's necessary in sort of fulfilling their purpose, so their investigative purpose. Because facial recognition technology involves the processing of personal data and specifically biometric data, it falls under the remit of the data protection instruments, so the Data Protection Act, the UK GDPR. Because the police are public authorities, they must also comply with the provisions of the Human Rights Act. And under the Protection of Freedoms Act 2012, we have specific provisions relating to the use of surveillance cameras. And under the broad definition of surveillance cameras within that act, facial recognition can be interpreted to be a surveillance camera, so can fall within the provisions of that act. However, the two areas which are more recent and which have gone through changes within the past year in order to take into account the use of this technology, and the ones that I kind of want to focus on a bit more, are the Surveillance Camera Code of Practice, which is provided for in the Protections of Freedom Act, and the College of Policing Authorized Professional Practice document on the use of facial recognition technology. So the Surveillance Camera Code of Practice was confirmed after a short consultation in 2021 and came into effect in February of this year. And it provides general guidance for the use of surveillance cameras by public authorities. So it's specific to public authorities. With regard to live facial recognition technology, as far as I'm aware, it's the first instrument we have which explicitly recognizes that as a technology in a statutory instrument. And so it requires public authorities, the police in this case, to set out and publish the criteria, the categories of people to be included on a watch list, as well as the criteria to be used in determining when and where to deploy the facial recognition technology, and the need to do so for a lawful policing purpose. It also sets out criteria that biometric data, which doesn't alert, which doesn't produce a result, is deleted instantaneously or near instantaneously. It states that public authorities must have regard to the public sector equality duty in the use of it. So any algorithms which disproportionately impact on certain groups, that would be in breach of that. So they must take that into account. And also that public authorities must establish an authorization procedure and deployment procedures and basically policy documents. Any use of the technology under the Code of Practice has to be justified and proportionate, but there are no prescriptive guidelines and there's sort of no concrete guidance as to what that might be. And in fact, in the guidance, in the Code of Practice, it explicitly states that it wouldn't be proper to provide specific operational or technical requirements that would be followed. So it's for the individual public authorities to do so. The authorities need to have regard to the code, but there's no liability in either civil or criminal proceedings if they don't, or for failure to comply. So it really lacks the necessary rigor as an oversight instrument, as a clear legal framework. The second instrument I want to mention is the College of Policing Authorized Professional Practice document on live facial recognition technology. And that came out in March of 2022, or that was confirmed in March of 2022. It was done in part in response to an earlier case of Bridges versus South Wales Police, which stated that there should be guidance as to when deployment could be authorized and who could be on watch lists. So it was in part in response to that. And it sets out a general approach to be taken within individual police forces, requiring them to set out specific provisions. However, the discretion does remain within the hands of the individual forces and how they deploy the technology and whom they're targeting on the watch list. It's still sort of being seen how this is going to be effective in practice, how effective this will be. It was in fact debated in the House of Lords earlier this week, with questions being raised as to whether this was sufficient for a legal framework governing this technology. Speaking for the government, Baroness Williams of Trafford stated that they supported the guidance and they believed that that was sufficient to meet the requirements of a legal framework. An important part of this, and an important part of assessing whether the technology is used or strictly necessary, is in the creation of Watchlist. And Watchlist are the individuals who are being sought by the technology. So it's a compilation of biometric templates which are imported into the system and then compared against the biometric templates of individual members of the public who pass through that public space. And in this, we see questions being raised about whether the requirements for strict necessity are actually being met, because the guidance on who can be incorporated into the watch list is very, very broad, particularly from a UK perspective. So the College of Policing guidelines state, that there are a variety of different criteria for including somebody on a watch list. The first is that individuals who are wanted by the courts can be included, individuals who are suspected of committing an offense or where there are reasonable grounds to suspect that the individual is about to commit an offense. So a very sort of preemptive mechanism in that regard. Individuals who are subject to bail conditions, a court order, or other restrictions that would be breached if they were in the location at the time of deployment. This is quite broad. It's not clear from the guidance how far this extends. And you could see here the potential, for instance, if somebody, a particular protest group, has injunctions levied against them, breach of an injunction by going into a particular area would bring them in contempt, and therefore could potentially, those groups, which are often associated with things like environmental protests, be subject to inclusion on a watch list under this criteria. There's also a criteria for individuals presenting a risk of harm to themselves or others, which equally is quite broad and quite vague. And the final criteria is any individual who would have information of importance or relevance to progress an investigation, or who is otherwise a close associate of an individual, and that individual would fall within any of the above categories. So in this regard, this is equally very broad, and you're not just looking at individuals who have committed or are suspected of committing criminal offenses. You're looking at victims, you're looking at witnesses, you're looking at associates of those individuals as well. Now, within the guidance, there are some examples of who might fall into this, but they are just that. They are examples. There's no clear parameters to the scope of application. So it is open to very broad interpretation. And in fact, the Biometrics and Surveillance Camera Commissioner, who's one of the very few oversight bodies which looks into this, spoke out about this last criteria about victims and witnesses, and said, if this envisages tracking people and approaching them to confirm whether they were at a certain place on that date and time, and inviting them to disclose what they heard, what they saw, solely because a surveillance system thinks they were present, that's a new and somewhat sinister development, which potentially treats everyone like a walk-on extra on a police film set, rather than as an individual citizen free to travel, meet, and talk. And he states that if it is used in this way, it very much calls into question the legitimacy and the proportionality of the mechanism. And in that regard, that would trigger fundamental rights concerns. Just for a point of comparison, because the EU is similarly discussing the issue of live facial recognition in publicly accessible spaces. And I know this is the topic of the next panel, so I won't go into too much detail here, but just to flag up the sort of comparator provisions within the proposed EU AI Act. The criteria for inclusion on a watch list are much more narrowly defined, although I would argue still potentially quite broad. But so there are targeted searches for specific potential victims of crime, including missing children, prevention of a specific, substantial, and imminent threat to life or physical safety of natural persons or a terrorist attack, or a perpetrator who commits one of 32 categories of offenses which fall under the framework decision on the European arrest warrant. And those are all what would broadly fall under the definition of serious crime, as opposed to the more broad proposals. And the serious crime threshold is one that's been recognized by the European courts as an important one in ensuring that broad surveillance measures fall within sort of the necessary, or within proportionate use, within a legitimate interference with the rights.
Allison, just to let you know, you have 2 minutes to wrap up.
Sorry, Federico, were you?
You have 2 minutes to wrap up.
Okay, thank you. Okay, so just quickly then, a couple other areas, one of which is the oversight. The oversight position within the UK is again different to that proposed by the EU AI Act. So the EU AI Act proposes pre-authorization by judicial authority or independent administrative authority, which again is much more in line with the relevant jurisprudence. There's no such requirement in the UK. It's just authorization by an authorizing officer of the rank of superintendent, but that can be removed in emergencies, with the aim that there will be oversight by somebody who is operationally removed from the deployment. But again, that falls well short of the requirements of independent oversight. Just in the interest of time, I'm just going to skip through the last thing. One other area of concern is where there is a public-private collaboration. So there have been reports of police sharing information with private companies for the creation of private watch list or private use of facial recognition, which again raises significant questions about the impacts of this on individual rights. And I just wanted to quickly touch as a last bit on the future developments, because there's been a lot of talk about the DCMS strategy, and within the realm of facial recognition technology, one of the proposed measures is to get rid of the Office of the Biometrics and Surveillance Camera Commissioner, which their role is to set the provisions for the Surveillance Camera Code of Practice. They've been recognized in the adequacy decision as an oversight mechanism in this area. However, their role is already fairly limited. They don't have any enforcement provisions, and the proposals are to then incorporate them with the ICO. And Karen spoke yesterday about some of the concerns with the proposals regarding the independence of the ICO. And I think that will be exacerbated by further bringing another area within the remit of the ICO, rather than subjecting it to sort of explicit independent oversight.